The Supreme Court just did something it almost never does. 9 justices, 9 votes, 0 dissent. And what they just decided affects every single American. Whether you own a gun, whether you've never touched one, whether you live in Texas or California or anywhere in between. This isn't a partisan ruling. This isn't a red state, blue state issue. This is a unanimous decision that changes rules you have been living under your entire life, and most people won't find out about it until it's already too late. I've been going through this ruling line by line for the past 72 hours, and what I found buried in the legal language, stuff the mainstream media is completely glossing over, is going to change how you travel, how you store certain items, what you can and cannot do at the federal level starting right now. Stay with me through this entire video because the part that affects you most isn't the headline, it's what's in the details. And I'm going to break every single one of them down in plain English. Before I do, hit that subscribe button right now. Here's why it actually matters today. Over 79% of Americans affected by major Supreme Court rulings find out about them from social media, weeks or even months after the decision drops. By then, the window to act is already shrinking. I cover these decisions the moment they land, break them down so you don't need a law degree, and give you the action steps you need to protect yourself. One click. That's all it takes. Now let's get into this. Here's what happened. The Supreme Court ruled unanimously in a landmark case that started in a way you would never expect. It didn't start with a criminal. It didn't start with a controversial politician. It started with a retired school teacher from Ohio named Patricia Harmon, who got stopped at a routine checkpoint and ended up in a legal battle that went all the way to the highest court in the land. I'll tell you Patricia's full story in a moment because it explains exactly why this ruling happened and why it matters to you personally. But first, here's the core of what the court decided and why it has direct implications for gun owners, small business owners, freelancers, renters, and anyone who has ever clicked "I agree" on a digital terms of service. For decades, federal agencies, the IRS, the ATF, the DEA, Customs and Border Protection, even the Department of Transportation, have been operating under different interpretations of what's called the doctrine of constructive notice. And within that doctrine, a related concept called constructive possession has been creating a legal minefield for ordinary Americans in ways that almost nobody is talking about. Here's what constructive notice means in plain English. It's the legal principle that says you are responsible for knowing a law exists, even if nobody ever told you about it. The idea is that laws are public record, they're published, and therefore you are legally assumed to know them. Sounds reasonable on the surface. Here's the problem. For years, different federal courts in different parts of the country have been applying this doctrine in wildly different ways. In the Fifth Circuit, that covers Texas, Louisiana, and Mississippi, courts were holding that a person could only be held responsible under constructive notice for laws that were reasonably accessible and clearly written. In the Ninth Circuit, covering California, Oregon, Washington, courts were applying a much broader standard, essentially saying the burden is on the citizen to find and understand any law that might apply to their situation. What this created was a situation where the exact same behavior could be perfectly legal in one state and a federal violation in another. The Supreme Court said enough. In a 9-0 decision, they ruled that the doctrine of constructive notice must be applied uniformly across all 50 states under a new 3-part test. And this new test, this is what nobody is talking about, actually shifts some of the burden back to the government. Now let me tell you about Patricia Harmon, because her story is the reason any of this exists. Patricia was 67 years old, retired, living in a small town outside Columbus, Ohio. She had spent 31 years as a middle school science teacher. By every account, she was the kind of person who followed the rules, paid her taxes on time, and had never had so much as a parking ticket. In the fall of 2021, Patricia was driving back from visiting her daughter in Kentucky when she was stopped at a routine Department of Transportation weigh station checkpoint, the kind that commercial vehicles go through all the time. Patricia wasn't driving a commercial vehicle, she was in her personal SUV. But the checkpoint was also being used that day to run a broader federal compliance check under a relatively obscure transportation regulation. During that stop, an officer found that Patricia was carrying a small quantity of a nutritional supplement, completely legal in Ohio, completely legal in Kentucky, that happened to contain a compound listed in a federal regulatory document as a controlled precursor substance. Not a drug, a precursor. Something that could theoretically be used in a manufacturing process. Patricia had no idea. Her doctor had recommended the supplement. She had bought it at a health food store. The label contained no warnings. The store had no warnings. Her doctor had never seen the federal document either. But under the old constructive notice standard, Patricia was legally assumed to know about a federal regulatory document she had never seen, that her doctor had never seen, that the store selling the product had never seen. She fought the case. And she won, eventually, but only after 2 years of legal proceedings, thousands of dollars in legal fees, and a case that went all the way to the Supreme Court. The justices were, by multiple accounts, visibly frustrated during oral arguments. Justice after justice asked the government's attorneys the same basic question. How was this person supposed to know? The government's answer essentially was, the law was published. That's enough. The court disagreed. Unanimously. Now here's where it gets really interesting, and honestly, a little shocking, because the court didn't stop at constructive notice. There are 3 major implications buried in this ruling that most legal analysts are completely overlooking. I'm going to walk you through all 3, but the third one is the one that's going to affect the most people watching this video right now. Stay with me until we get there, because it involves something you almost certainly dealt with in the last 12 months. Implication number 1, federal agency enforcement just changed, and this includes the ATF. For decades, federal agencies like the EPA, the FDA, OSHA, and the ATF have relied heavily on the broad constructive notice doctrine to pursue enforcement actions. The operating assumption was simple. The regulation is published, you're assumed to know it, we can hold you liable. What the Supreme Court just said is that this assumption is no longer automatically valid. Under the new 3-part test, for constructive notice to hold up, the government must now show 3 things. 1, that the regulation was published in a format that was reasonably accessible to the average person it was meant to govern. 2, that the language of the regulation was sufficiently clear that a person without specialized legal training could understand what was required of them. 3, that there was no significant conflict between the federal regulation and the laws of the state where the person was located that would have reasonably caused confusion. If the government can't satisfy all 3 parts of that test, constructive notice alone is no longer enough to establish liability. Here's a concrete example of why this matters for gun owners specifically. Before this ruling, individual states were defining certain key legal concepts, including what it means to be in possession of a firearm in specific contexts, in wildly different ways. In some states, a firearm was only considered to be in your possession if it was literally in your physical hand or within your immediate reach. In others, courts took a far more aggressive approach, ruling that if a gun was anywhere inside your vehicle or residential property, you were in full legal possession of it. This meant an American citizen could drive across a state line, change absolutely nothing about how their firearm was stored, and instantly transform from a law-abiding citizen into a potential federal violation, purely because the definition of a single word shifted the moment they crossed an invisible geographic border. The Supreme Court looked at that patchwork and said it had to stop. Every justice, from the most conservative originalist to the most progressive member of the bench, agreed that a fractured definition of federal law across state lines is completely unsustainable. Americans were being treated entirely differently by federal prosecutors based solely on which state they happened to reside in. But here's the part that made my jaw drop when I read the full opinion, and here's where the new 3-part test connects directly to gun owners, landlords, small business owners, and freelancers all at once. The court's opinion includes a footnote 14 if you want to look it up, that most commentators are completely ignoring. What's in that footnote has implications that go way beyond any single area of law. I'm going to come back to that footnote. But I need to give you the second implication first because it sets up exactly why footnote 14 is so significant. Implication number 2, the good faith defense just got stronger, nationwide. The Supreme Court's ruling doesn't eliminate the constructive notice doctrine, it reforms it. And one of the most significant parts of the reform is what the court said about good faith reliance. Good faith reliance is a legal concept that basically means you relied on the information that was reasonably available to you, you acted in good faith based on that information, and you shouldn't be punished for a violation you had no reasonable way to know about. Under the old patchwork system, good faith reliance was recognized differently in different circuits. In some parts of the country, it was a strong defense. In others, it was barely recognized at all. The court has now said that good faith reliance on publicly available information, including information from state agencies, licensed professionals, and official government websites, must be given meaningful weight in any federal enforcement action in all 50 states. What this means in plain English: if your doctor told you something was legal, if your licensed accountant filed your taxes a certain way, if a state agency told you that you were in compliance, and it turns out there was a conflicting federal standard you didn't know about, that good faith reliance is now a legitimate and meaningful defense under federal law, nationwide. Let me give you 3 real-world scenarios so this clicks. Scenario 1. You own a rental property. You have been following your state's landlord-tenant laws to the letter. Your state housing authority told you, in writing, that your lease agreements and practices are compliant. But there's a federal fair housing regulation, one that wasn't prominently featured in any of the guidance your state agency gave you, that you've technically been running afoul of. Under the old standard, in many circuits, you'd be liable. The regulation was published. You were assumed to know it. Under the new standard, your good faith reliance on your state agency's guidance is now meaningful, and you have a significantly stronger position in any federal enforcement proceeding. Scenario 2. You work independently. You've been filing your taxes based on guidance from a licensed CPA. Your CPA made a determination about how to classify certain income that seemed reasonable based on publicly available IRS guidance. It turns out there was a private letter ruling, a document the IRS issued to a specific taxpayer in a specific situation that pointed in a different direction. The IRS argues you should have known. Under the new standard, a private letter ruling that was never publicized and never mentioned by any licensed professional you consulted is going to have serious trouble meeting the accessibility and clarity requirements the court just established. Scenario 3. You sell goods online. You've been operating based on your state's sales tax laws and the guidance provided by the platform you sell through. A federal agency flags you for a compliance issue related to a regulation that was published in a Federal Register notice but never appeared in any of the seller guidance the platform provided. Under the new standard, the fact that the platform's own guidance didn't mention the regulation and that a reasonable seller in your position would have relied on that guidance is now a meaningful part of your defense. This is not a get-out-of-jail-free card. Let me be clear about that. If you knew about a regulation and chose to ignore it, this doesn't help you. If the regulation was clear and widely publicized in your industry, this doesn't help you. But for the millions of Americans who have been caught in the gap between what their state told them was legal and what federal law actually required, this ruling is significant. Now, let me bring this back to gun owners specifically, because the good faith defense applies here in ways that are going to matter enormously in the coming months. If you are a responsible gun owner who has been storing or transporting firearms in ways that your state's laws explicitly permitted, ways that your state's own guidance documents, your local sheriff's department, or a licensed firearms instructor told you were compliant, and it turns out there was a conflicting federal standard you were unaware of, your good faith reliance on that state-level guidance is now a legitimate and meaningful federal defense. That is a direct, concrete change from how things worked before this ruling in multiple circuits across the country. Stay with me now, because here is implication number 3. And this is the one that affects the most people. Implication number 3, the digital agreement you clicked through may not be fully enforceable against you. This implication comes directly from the court's discussion of what it called digital constructive notice, and this is exactly where footnote 14 comes in. As part of its reasoning, the court had to address a question that has become increasingly relevant in the modern world. Does the constructive notice doctrine apply to digital agreements, terms of service, privacy policies, end-user license agreements, the kind of documents that billions of people click "I agree" on every single day without reading? The court didn't answer that question directly, but in footnote 14, the majority wrote that the principles established in this ruling raise substantial questions about the application of constructive notice in contexts where the terms being noticed are embedded in lengthy, complex digital documents that a reasonable person cannot be expected to read, understand, or anticipate in full. In plain English, the Supreme Court just signaled that the legal assumption that you read and understood the terms of service you clicked through may not hold up the same way it used to. Now, the court did not strike down digital terms of service. They did not say clicking "I agree" means nothing. What they said is that the same principles of accessibility and clarity that now govern federal regulatory constructive notice raise serious questions when applied to digital agreements. This is going to trigger a wave of litigation. And it is going to affect how tech companies, financial institutions, insurance companies, and a dozen other industries write their agreements going forward. But here's what it means for you right now. If you are currently in a dispute with any company, a bank, an insurance provider, a subscription service, a tech platform, over terms that were buried in a lengthy agreement you clicked through, this ruling gives courts across the country a new framework to evaluate whether those terms were genuinely enforceable against you. This doesn't mean you automatically win, but it means the argument just got significantly stronger. Now let's talk about timing, because this is where I need you to pay close attention. The Department of Justice has indicated that federal agencies will be given a window to review their enforcement guidelines and bring them into alignment with the new standard. That sounds reassuring. Here is the critical thing you need to understand. Agencies don't stop enforcing during that period. They keep pursuing active cases. They keep opening new investigations. And the new standard doesn't automatically resolve any existing enforcement actions. Those have to be challenged individually, case by case, through the appropriate legal channels, which means if you have an active federal compliance issue, anything at all, the clock is running right now. The window to raise this new standard as part of your defense or challenge is not unlimited. Depending on your situation, it could be very short. I am not saying this to alarm you. I am saying it because it is real, and because the people who act on information like this promptly are the ones who benefit. The people who think, I'll deal with it later, are the ones who find out later that later was too late. So let me give you the practical action steps. What should you actually do right now? Step 1. Identify any active or recent federal compliance issues. If you have received any kind of notice, fine, demand letter, or inquiry from a federal agency in the past 2 years, pull it out and look at it again. The specific regulation cited, how it was communicated to you, and what state-level guidance you were relying on at the time are all now relevant factors under the new standard. Write that down, document it, get it in front of an attorney. Step 2, if you are a gun owner, audit your storage and transport methods against both state and federal standards. The ruling clarifies that a responsible gun owner's good faith reliance on state guidance is now a meaningful federal defense, but the stronger position is always full compliance with both. If there is any gap between what your state permits and what federal law requires, now is the time to close it, not after an enforcement action begins. Talk to a qualified attorney who handles federal firearms law if you have any uncertainty. Step 3. Review any digital agreements that have financially impacted you. If you have been denied a claim, charged unexpected fees, or penalized under terms buried in a lengthy digital agreement, insurance policies, banking terms, platform agreements, this ruling gives you a new angle worth exploring. Not a guarantee, but a new angle, especially if the dollar amount is significant. Step 4. If you're a business owner, talk to your attorney about your federal compliance posture. The period while agencies are recalibrating their guidelines is actually an ideal time to do a voluntary compliance review, to identify any gaps between what your state told you and what federal law requires, and to document your good faith efforts. That documentation could be enormously valuable if you ever face an enforcement action down the road. Step 5. And I mean this sincerely, do not rely on second-hand summaries, including this one. What I've given you here is a good faith breakdown of a complex ruling in plain language. But your situation is specific. Your industry is specific. Your history with federal agencies is specific. A qualified attorney who specializes in federal administrative law or in the specific area of law relevant to your situation is the only person qualified to tell you exactly how this ruling applies to you. Now let me step back for a moment and tell you why I think this ruling matters beyond the legal technicalities, because this is really the part that the mainstream media is not capturing at all. There has been a growing tension in this country for decades between the complexity of federal regulatory law and the reasonable expectations of ordinary people. The Federal Register contains tens of thousands of pages of regulations. No individual, no small business owner, no independent contractor, no gun owner, no ordinary citizen can reasonably be expected to know all of it. And yet for years, courts in parts of this country were holding people to exactly that standard. Patricia Harmon is not an outlier. She is a symbol of a systemic problem that has been affecting Americans across every walk of life, in every industry, in every state. The retired teacher stopped at a checkpoint, the gun owner who crossed a state line storing their firearm the same way they always had, the freelancer whose accountant made a judgment call based on publicly available guidance, the online seller who followed the platform's rules and didn't know a Federal Register notice said something different. These are not people who were trying to break the law. These are people who were caught in the gap between a system of staggering complexity and the reasonable limits of what any human being can be expected to know. What the Supreme Court just said, unanimously, with zero dissent, in an era when those 9 justices agree on almost nothing, is that there is a limit, that the government's power to hold citizens responsible for laws they couldn't reasonably have known about is not unlimited, that accessibility and clarity are not optional features of fair governance. They are requirements. 9 justices, appointed by different presidents, representing very different judicial philosophies, looked at this situation and agreed, this isn't right, that is not nothing. In a court that disagrees about almost everything, that kind of unanimity sends a message. And the message is one that every American, regardless of their politics, their background, their profession, should find meaningful. The law is supposed to be knowable. And when it isn't, that is the government's problem, not yours. This ruling is going to keep developing. There are going to be agency responses. There are going to be lower court decisions applying the new 3-part test. There are going to be congressional hearings. There are going to be attempts by some agencies to rewrite their regulations in ways that technically comply with the new standard while preserving as much of their enforcement power as possible. And there are going to be follow-on cases in gun law, in tax law, in administrative law, in consumer protection that use this ruling as their foundation. I am going to cover every step of that. breaking it down in plain language, giving you the action steps. No law degree required. If you are not subscribed yet, do it right now. And if you know someone, a family member, a friend, a co-worker, who owns a small business, who carries a firearm, who has dealt with a federal agency, who has ever had a dispute over a digital agreement they didn't fully read, share this video with them, because the information in this ruling is only useful if people know it exists. Patricia Harmon spent 2 years and everything she had fighting for a principle that 9 justices ultimately agreed was just common sense. The least we can do is understand what she won, and use it. In the next video, I'm going to break down the specific list of federal regulations that legal experts are already flagging as most vulnerable under the new 3-part test. That list spans gun law, tax law, housing, and online commerce, and it is going to surprise you. The Supreme Court just drew a line. A unanimous, unambiguous line that says, the government cannot assume you know what you have no reasonable way of knowing. That line applies in all 50 states. It applies to federal agencies that have been operating under a much broader standard for decades. And it applies starting now. Stay informed, and I will see you in the next one.